Okay, good morning, everyone. Thank you all for being here. We have a lot of business to attend to today, so we'll get right to it. Moving right to the approval of the minutes from the public portion of our meeting, which was conducted on June 26th. The minutes were distributed in your packet, and they are behind tab A. Are there any comments on the minutes? I believe that Commissioner Yarashevsky had an issue that she communicated. She is on her way. She will be a few minutes late. What was her?
She communicated that the minutes should reflect that her inability to Skype the last session was due to a technological difficulty and that she was unable to Skype in because of that.
Okay. We'll have the minutes properly reflect that. Is there a motion on the table to approve the minutes?
So moved.
Second?
Second.
All in favor?
Aye.
Aye.
Any opposed? Motion to approve the minutes is carried. Thank you. Moving right straight away to the Executive Director's report. Ellen?
Thank you. First, I want to start with the update on staffing. We have hired 2 new staff members. An associate counsel for ethics and lobbying compliance has joined the staff, as has a manager for training. We continue to post and recruit for the remaining open positions.
Any questions or comments of Ellen? Or Ellen, rather.
If there are none on that, I'm going to move to the next update, which regards our new website. So I'm going to switch places for the moment. As you know, creating a new website for the agency was a priority. And today, as soon as we're done with the webcast and this meeting, we didn't want to disrupt that, we will be going live with a new website for the agency. It is easier to navigate. It makes the agency and the information, the publicly available information, much more accessible. And for these reasons, we think that it is a great development, and I'm very grateful to staff. They had very limited resources and really did an amazing job with those limited resources to create this new website. I want to show you a few aspects of it just quickly, and then, as I said, we will be going live this afternoon after the meeting. Across the top, if you see here, this gives these are drop-down menus to give easy access to who's the commission, what is our jurisdiction and authority, laws and regulations, and other information about us. Again, along the top, easy access by a drop-down to advice and guidance information. There will also be easy access to training and filings and easy ways to contact us. Along the side, easy access to how to make a tip and a complaint. Previously, that was not so accessible. We think that that should be immediately accessible to people. That's, again, right on the side. Another easy access for training, a calendar which will list filing deadlines, meeting dates, and other information. Helpful links or links to other helpful websites. On the bottom, this feature is where it says IMA. That's for easy access for people who may not understand what information they are looking for or how to navigate the website. This is an easy way based on the category of person or entity. If you click on that, for example, I am a lobbyist, it gives you a menu of some of the information or access to filings that you might be interested in based on who you are. If you go back to home, obviously same types of options if you're a client, a public corporation, state employee, and then also importantly on the bottom, member of the public. If you're a member of the public, I'm a member of the public, will give easy access to some of the publicly available information that a member of the public might be interested in. And then on the bottom, if you go back to the home, again, very quick and easy buttons to submit a filing. That will be easy access to the lobbying registration and reporting, to the electronic filings of the financial disclosure statements, or if someone just wants to view a filing, some of the publicly available information, that will be quick access from that tab on view a filing. And then, of course, another way of accessing the public information, which is our publications, including annual reports, press releases, enforcement actions, e-blasts, and commission meetings. Perhaps just as critically, however, this is what we see as a very important first phase of the website, but we see this website as a critical foundation for some of what we would call the next phases. And we hope to implement some of these next steps soon, in the near future. And as we get additional information and data through, for example, some of the new reporting requirements that we'll be discussing today, this new website will be an important platform for making all of that new information accessible and available as easily as possible. So I want to highlight some of the next steps that we envision, but as I said, these are just a few of the next steps that we envision are going to be enabled by the new website. So first, am I controlling? The next phase will include better access to the lobbying and client information. So, for example, some of the new requirements that we've been talking about, access to the reportable business relationship and source of funding information by being able to view and search the reports. As we get the information, the new website will have features to make that information much more accessible. And also the lobbying nature of business. As you know, that's an area that typically in the annual report we would be summarizing. We think that's something that we should be summarizing and making available much on a more frequent basis. So we're going to be making that available as well. We also intend to make access to the information about the elected officials more accessible and available. As you know, starting after January of 2013, the financial disclosure statements of the legislators and the 4 statewide electeds will be online. This will be an important platform to make all of that information available. And we also intend to cross-reference the publicly available campaign finance data, which will allow kind of an interesting analysis for the public once you're able to access both types of data. Also, as we update and upgrade the training and education programs that we have, the website will be an important mechanism for making that all very available, very accessible just from the desktop. And obviously, you know, one of the main goals and priorities is just generally making JCOB, the agency, more accessible to the public and to the regulated community. And we will include, in that regard, a glossary of terms, online requests for opinions and guidance. We are in the process of expanding and improving the advisory opinion finder, and that will be implemented into the new website when it's done. We also anticipate the ability to allow members of the public to subscribe to the commission e-notification so that they'll be getting the notices and the e-blasts if they subscribe for that. And other tools for generally easier access to the publicly available materials. Thank you.
Any questions, comments? Okay, nicely done, very nicely done, thank you. Okay. Ellen, does that conclude your report?
That concludes our report.
Okay, very good. So moving along to Item number 4, Lobbying Act Guidelines and Regulations. Seymour?
Well, I just had a quick question on the web, and
On the website?
how do we get out to the general public about changes that we've made?
Well, I think the website is itself a way to get the information out there. So
Are we going to issue a release on the new site?
we may, in fact, do an e-blast, but of course that only goes to the regulated community. And of course, we're announcing it now during this meeting, which is webcast. But it's a good point, and we should get the message out because it is a much better website, and it will make the agency and information much more accessible.
What do you think it sends out a really positive vibe about what we're doing?
Perhaps maybe once we go live after the meeting, we can do something of that sort.
Okay, very good. So moving along, so we all are aware that the new reportable business relationship and source of funding disclosure requirements are obviously significant reforms that have been passed this year. And we know that the goal of the reform is to be certain that the law is doing its best so that all New Yorkers are better informed about the ways in which the government decision-making process is impacted. We have been busy, the staff has been very busy developing and drafting the proposed regulations for the new source of funding disclosure requirements and guidelines for the reportable business relationship disclosure requirement. Ellen and the staff have worked very hard, along with many of the commissioners in this room, to bring today a draft product, or proposed product, I should say, for us to review. I know it has been distributed, I believe it was distributed last week, so that everyone could have an opportunity to look at it, to study it, to think about it, and come today prepared to engage in discussion that will lead us, hopefully, at the end of this session, to adopting a product that we could get on with the process of finalizing the implementation of the regulations and the guidelines. So with that said, I'm going to ask Ellen to take us through. Ellen, I think you should just remind everyone of the law itself, and then we can move into the proposed regulations.
So let me tell you what my plan is. And before I begin, I also want to thank and acknowledge Rob Cohen, who's our Director of Lobbying and Ethics Compliance, and his team. Rob has really hit the ground running, and he and his team have done really extraordinary, thoughtful work on these. So I want to thank them.
Yes, thank you, Rob.
What I'd like to do now is I would like to run through with you the seminal provisions of both the proposed guidelines and the proposed regulations. Before we get to that, though, and I actually have a PowerPoint presentation that I want to walk you through, I just want to frame for you the context. With respect to the proposed regulations for the source of funding disclosure requirement, those are proposed regulations, and what we would ask of the Commission is, after discussion, we would ask that you vote to approve those to be draft regulations that would then go through the SAPA process, which, as you know, is a process that involves at least a 45-day period of additional public comment, and then it would come back to the Commission to finalize. Yes.
Can you just, before you get into the substance, walk us through what we've done to date? We had some public hearings.
Yes.
When those public hearings were,
Yes.
and the distribution of the drafts, to put in context, I think, the amount of work that's been devoted to this already.
Okay.
That would be helpful. Yeah.
Okay. And so on that point, as you know, in mid-May, we solicited public comment for both the new disclosure requirements, and that is both the source of funding disclosure requirement and the reportable business disclosure requirement. Those are two new requirements that were implemented under PURA as new provisions of the Lobbying Act. And they are unprecedented, and so, which means two things. One, it means New York is a leader of sorts in promoting this kind of transparency in lobbying and the government, but it also means there's not a lot of precedent to draw from. So we did solicit public comment, and we received public comments on both provision, and we held a hearing on June 7th. Where a number of groups came and provided productive and informative testimony regarding their proposals on how these various provisions should be interpreted and how the regulations and guidelines should be promulgated. And staff has drawn on those public comments, on the comments and testimony at the hearings, in developing the drafts that we've now distributed to you. It's come, obviously, in a number of different iterations, and we are grateful to the commissioners who have, over the last few weeks, have been engaging in productive dialogue regarding these drafts. So we appreciate I appreciate the time not only that staff has spent, but also that the commissioners have spent so far.
Just a point, I know you were busy working last night, even making some changes. Those of us in hotels may not have been able to print them. Do we have any hard copy of the latest?
It's in front of you.
Okay. I know I got, but I don't know.
I believe
just
those
asked
were
for it.
distributed, yes.
Oh, okay.
That's the background and context. And so there are two different forms that we're looking at. For the source of funding, they are proposed as regulations, and as I said, what we would be asking the commission to do is consider these to ratify them, and then from that we would engage in the SAPA process with respect to the source of funding regulations. With respect to the guidelines for the reportable business relationship, our proposal there is we are asking the commission to consider and approve those proposed guidelines, and our proposal would then be for us to post those as proposed guidelines, and that we would solicit additional public comment after we had posted them for a period of time, and then we would come back to the commission to finalize those guidelines to see if there were any reason to make any significant revisions.
So post them on the website.
We would post them on our new website. And as I said, and provide for an additional time period to solicit additional comment to the guidelines, and then we would be in the position to come back to the commission to raise any issues if there's a need for any significant revision before finalizing them. So in both instances, the point is we are asking you to ratify both of these the regulations and the guidelines as proposals that will then be subject to additional public comment and then to additional revision if necessary.
What's your time frame?
That's a great question. The reportable business relationship requirement, as you know, went into effect as soon as PURA went into effect. So that is in effect currently, and we have already encouraged people to comply with the law as it reads, based on their best reading of the law, without the guidance up. So we would very much like to get guidance up as soon as possible to help the regulated community and give them guidance on that compliance. On the source of funding requirement, you remember there, that went into effect June of this year. And as I'm about to run through with you, because that went into effect June of this year, we believe that reporting requirement will apply starting July of this year. For the reporting period for the semi-annuals goes in 6-month period. So for July through December, we believe that's when the source of funding first applies, which means the first filing that would involve this requirement would be in January of 2013. However, because we're talking about compliance with a provision that applies starting now, we do think it's critical to get these regulations in place as soon as we can, and the SAPA process requires at least a 45-day period for public comment. So that means if we go, even if it's ratified today and it goes through the SAPA process.
So we're looking at the October meeting?
Yes, we're looking at, probably September or October, which we think is, is getting late, and we're trying to get this done as expeditiously as possible. So, but that I appreciate your asking that, because I think the timing is an important piece of this. But with that said, I'm going to turn now to some of the substantive provisions. What I'd like to do is run through the substantive provisions of both for source of funding and reportable business, and then we can open it up for discussion. Okay. Eric, am I controlling? Okay. The source of funding regulations are to be promulgated pursuant to the statute. The reporting requirement is in the legislative law. I'm going to read it for you. The reporting requirement for source of funding is as follows. Any client of a lobbyist that is required to file a semi-annual report, and one, that has spent over $50,000 for reportable compensation and expenses for lobbying, either during the calendar year or during the 12-month period prior to the date of his semi-annual report, and two, at least 3% of whose total expenditures during the same period were devoted to lobbying in New York, shall report to the Commission the names of each source of funding over $5,000 from a single source that were used to fund the lobbying activities reported, and the amounts received from each identified source of funding. There is similar language, identical requirement for any registered lobbyist who performs lobbying activity on its own behalf and not pursuant to retention by a client. And on that point, that's simply, there are some clients who are their own lobbyist, so they are considered both a lobbyist and a client. It is the same requirement for both. So that's what this is the background. This is what we're trying to implement the regulations to give clarity and guidance to. What we're going to be talking about today is we believe that the drafts that we are developed, these are some of the critical points. They maximize public disclosure by setting clear rules for who must disclose, by setting clear rules for when disclosure is required. It provides a bright line rule for when funds are deemed used for lobbying activities pursuant to the statute. It includes an inclusive definition of single source. It provides for aggregation of funds over the calendar year to provide robust and meaningful disclosure. And they set a rigorous but fair standard for the exemptions. I'm going to talk about each one of these now. First, the clear rules for who must disclose. It's important to recognize that when we're talking about this disclosure requirement, there is a set universe of clients who must disclose. And before this disclosure applies, you must first meet a threshold test. And the threshold test is that test that they were, in the statutory language, the 50,000 and 3%. And it's what we'll be referring to throughout as the 50,000, 3% threshold. What that means is, before you're subject to disclosure, you must first determine whether you've actually had at least 50,000 in compensation or lobbying expenses, and that your lobbying expenses or compensation in New York State account for at least 3% of your total expenditures. Now, what that means, 3% sounds like it's small, but what that means is if 3% of your total expenditures are going to lobbying activities in New York State, that is a substantial amount of lobbying activity. And that is, the legislature, I believe, came up with this threshold as a way of saying, first, you must be an entity, a client, that is engaged in a substantial amount of lobbying activity in New York. That's what this threshold does. So first you have to meet the threshold. The regulations, though,
Before you go further,
Yes.
the very first one, which is 50,000 in compensation.
yes,
And/or,
where's and/or expenses. Under,
And/or.
right, it could be
Okay.
reimbursed expenses, too, because remember, some of these clients are also their own lobbyists.
okay. The reason I ask, because
Yeah.
the final draft regs that came in last night only use the word and, not or. So I just want to make sure we're on the same page.
I don't believe that that was a change we intended to make.
I mean, isn't that statutory driven?
It's
This is
statutory.
statutory.
I mean, the and, quite frankly, the and/or, I think, is, what does and mean within the context of the regs? I think it's an
Well, I
and
mean,
or.
and becomes
It should
an
be,
addition,
just to be
and/or is
clear,
an alternative.
it should be the same, it's driven by the statute. So to the extent that it's not identical to statute, it should be.
Okay, all right, so,
The time period, the statute talks about 12-month proceeding or the calendar look back. What we've done in the regulations is we've said as follows. The 12-month period, and this is just to determine whether you meet the threshold. The 12-month period runs from the 12-month preceding the last day of the reporting period for the semi-annual report. So the reporting period ends June 30th, then you go back to June 30th of the prior year through June 30th of that reporting period. That is the 12-month look back. If you meet the threshold in that 12-month period, you don't have to look to the calendar year, you've met the threshold, and you're done. But we do provide that if you don't meet it in the 12-month, we think you look to the calendar year, which would be the period that runs from January 1st to the last day of the reporting period for each semi-annual report. So the disclosure requirement will be triggered if you meet the threshold in either of those time periods. Okay. The proposed draft also gives clear rules for when disclosure is required. As I mentioned, the disclosure requirement is in the legislative law. Talks about clients shall report in their semi-annual reports, which, as you know, are filed twice a year. The first one covers the reporting period from January 1st to June 30th, and those are filed July 15th. And the second is for July 1st through December 31st, and those are filed January 15th of the following year. Those are the semi-annuals. In the regs that we have drafted, so long as the client makes the disclosure in the semi-annual report, they need not file the disclosure in the bi-monthly if they happen to be a client who's also a lobbyist. There is a small subset of clients who are clients and lobbyists and file both, but if you're filing in the semi-annual, you need not file elsewhere.
why do we give them an exemption?
It's not an exemption. They're filing in the semi-annual, and that's going to be clear, concise disclosure.
No, I understand that, but if it was not a client who's a lobbyist, then there would be a bi-monthly report.
There would be a bi-monthly, which would be in addition. They would file a bi-monthly in addition. There's about 20% of clients who are clients and lobbyists.
Right.
And so
My question is, if a
For that-
client hires a lobbyist, the public gets to know more of what's
No.
happening.
No. If a client, this requirement is only as to clients.
Correct. So if a client does self-lobbying, then they don't have to disclose other than every 6 months.
They disclose every 6 months. All clients disclose every 6 months, we say.
So
It
that's
would-
what I'm saying, why do they get preferential?
It's not preferential, it just means for a certain subset, it doesn't have to be redundant, and because that would be a redundant filing. They would file bi-monthly, and then they're also filing the semi-annual. Do you understand? They're filing both. So if you file in the semi-annual, you don't need to file in the bi-monthly, according to these
If a
regs.
client hired an outside lobbyist, the client would be filing every 6 months, and the lobbyist would be filing every 2 months.
It doesn't apply to the lobbyist filing. If you have an outside retained lobbyist, this disclosure is not in that filing.
But they're doing every 2 months filing.
They're doing every 2 months filing, but this disclosure requirement doesn't apply to that filing.
Madam Chair, if I may.
Yes?
Maybe it's a good idea if we hold questions to the end, because maybe Ellen's going to cover some of these things along the way.
Okay, fine, why don't we do that? Thank you.
So long as it's in the semi-annual, it doesn't have to be elsewhere. And as we said, this disclosure requirement went into effect June of this year. We believe that the fair and reasonable interpretation of that is that it went into effect June and that it should apply to the very next reporting period, which would begin July of this year, the month that we are in now, so that we say this disclosure requirement applies to the reporting period beginning July of 2012, so that the first time that this disclosure would be required is in the report that would cover the July to December reporting period, and that report would be filed in January of 2013, covering July through December of 2012. We also provide for a bright line rule of the statute talks about funds used for lobbying activities. There was a lot of debate about what that means. We believe that so long as the client meets that 50,000 3% threshold, which we've just discussed, then all contributions the client receives from a single source that exceed 5,000 must be disclosed. We think that this is consistent with the intention and language of the statute, which seeks to maximize disclosure. It also it closes potential loopholes in trying to figure out which dollar has gone to which lobbying activity, and it recognizes that money, of course, is fungible. We've also included an inclusive definition of single source. So that single source not only includes an individual or an entity that is providing the contribution, but it also includes certain related entities and certain relatives, and we say they should be deemed a single source such that those individual contributions to the same client or lobbyist will be aggregated to determine if the $5,000 contribution threshold has been met. And in particular, the provisions provide two types of aggregations of sort in this respect. First, if the client filer has actual knowledge that two or more persons live in the same household, then those persons are deemed a single source, and their contributions will be aggregated to see if they've met the $5,000 threshold. Similarly, when the client filer has actual knowledge or reason to know that two or more organizations or entities are related, then such organizations or entities will be deemed a single source if they have a certain type of relationship, and that includes the following: a parent corporation and its subsidiary, subsidiaries with the same corporate parent, national or regional organization and their local chapters of the same national or regional organization, and a sole proprietorship and the sole proprietor. We've also provided for aggregation of funds so that multiple contributions from a single source are aggregated within the calendar year to determine if the 5,000 contribution threshold has been met. For example, if the $5,000 threshold from a single source is met in the beginning of the year, then of course disclosure is required, as I've set forth, in that first report, which would be due in July. But if you have a contribution from a single source in that first reporting period that doesn't meet 5,000, but then you get a second contribution from that same single source in the second reporting period, we say you aggregate those two so that you would report those combined contributions, if they exceed 5,000, in the second reporting period, which of course would be due in the January of the following year. The statute requires two different types of exemptions, and it's up to the regulations, though, to provide standards for those two different types. And our draft, we believe, provides the rigorous but fair exemption standards that we think is called for by the statute. The first exemption standard is a clear and convincing standard. It provides that a client filer can make an application to us and present information when they show that a disclosure of a single source will cause harm, threats, harassment, or reprisals to the single source or individuals or property affiliated with the single source. And under this type of exemption application, they must make a showing to us, they must meet a clear and convincing standard. That's the first type of exemption. The second type of exemption that is provided for in the statute provides a substantial likelihood standard for certain 501c4 type organizations. These organizations can apply for an exemption for disclosure of all of their single sources, but they must show or demonstrate that the primary activities of the 501c4 involve areas of public concern that create a substantial likelihood that disclosure of its single sources will cause harm, threats, harassment, or reprisals to the single sources or individuals or property affiliated with the single sources. It is a slightly different standard, it is a slightly different focus, but okay. As you might recall, the statute refers to when you have a reason to know that an entity is connected to a state person. We provide a standard for that reason to know, and it provides a multi-factor test to determine when a filer has a reason to know that a state person has the required involvement with or ownership interest in an entity in which the filer has a business relationship. These factors include, but are not limited to, the origins of the relationship, the length of the relationship, the type and actual value of the goods or services provided, and whether the involvement or ownership is generally known to the public. The reason to know standard will not be found simply because some information might be in a financial disclosure statement that's filed with the Commission, or if it could be obtained through a FOIL request. We don't think that that is standard. However, the guidelines do make clear that willful ignorance is not acceptable, and that will be deemed as having reason to know. And finally, I think this is finally, the guidelines make it clear that both lobbyists and clients have an ongoing duty to amend, correct, or update their filings. So although the disclosures are required in the semi-annual report, which is filed twice a year, and the biennial registration, which is formally filed once every 2 years, they have an ongoing duty to amend, update, and correct these filings at any point in time if these relationships develop, or if any component of the relationships develops that would trigger these filings. They have a duty to amend, correct, and update. That kind of completes the seminal provisions in both the proposed draft guidelines and the regulations, and I think now we can open it for discussion.
So why don't we start with source of funding and the proposed regulations there. Any comments?
No, I've got questions. I just wanted to give anybody else a shot at asking the question. First of all, really impressed with the proposed reportable business relationship guidelines. Going to source of funding regs, I am as much troubled as I am pleased with the other. And I want to, because we couldn't do it as you were going through the presentation, so I'm going to go based upon the draft regs that we got last night, 11:30, if that makes sense to you.
Or if you want me to put the PowerPoint back up, if that helps you.
I think if you just look at the last thing that we got last night,
Okay.
about 11:30, this way, we'll cover it. Now, this is the law, PIRA was passed on August 15th of last year. And you've already well explained the look-back provisions for 12-month calculation, the calendar. I take some note in the fact that the requirements here include the last day of the filing in the prior reporting period. You know what I'm
The
referring to?
time period calculation for the threshold, what we've said is, the statute says 12 months preceding. We've defined that preceding 12 months to say, you take the last day of the reporting period that you're covering, and you take 12 months back from that. We believe, and the reason we did that, at least in part, one, it's driven by the statute, but we believe that at least some of that time period that you're looking at to see if you've met the threshold should include the reporting period.
Sure.
And so that's what that does.
Under responsible party, which is page 3 of the draft
Yeah.
regs we got last night.
That's driven by the lobbying law.
Yeah.
That's consistent with the lobbying law.
Okay. But if you go to A, under single source, and I'll read, quote, 2 or more persons whom the client filer has actual knowledge live in the same household, end
Right.
quote.
Right.
Now, that didn't come out of the statute.
So that's, no,
Okay.
that piece is all proposed regulation.
All right. Now, why are we limiting single source to relatives who living in the same household?
We're actually not limiting single source, we're expanding single source.
No, but just stay with A, though. If 2 or more people whom the client filer has actual knowledge live in the same household. So if you have brother and sister or uncle and nephew or whatever, and they're living in different households, they're not covered under A.
That's correct. That's
So
correct.
why are we taking such a restrictive definition?
Well, you know, that's been an area of much discussion that we've had the opportunity on you know, the various conversations that we've had with commissioners. There, initially, we had proposed, we've had a lot of internal debate about this. We've had the definition of relative under the public officers law at one point, but there was concern, and we thought, and we were compelled by the concerns raised, that was just too broad. You know, that would include cousins and, you know, direct descendants of grandparents, and there was a concern that that's just too broad
You're
for
talking about
aggregation.
6 degrees of consanguinity?
Yes, and that's the definition of the public officers law. The live in the same household was taken from the public officers law, but we thought was a reasonable compromise to allow for aggregation of certain related entities without going too broad.
So basically, unless relatives are living together in the same household, it's no longer a single source contribution.
That's how this is written.
Okay. And that's the
Technically
proposed
not even
guideline.
relatives.
I'm sorry?
Technically not even relatives. I mean, the definition, all definitions are going to be either under-inclusive or over-inclusive, and so this was the line we drew, but.
It doesn't have to be a relative
Doesn't have to
in
be
the
a
same
relative.
household. It's anyone in the same household.
Okay.
Anyone who the client filer has actual knowledge lives in the same household.
Now, why are we using the, again, restrictive, the standard of actual knowledge rather than the reason to know?
Well, we don't think this is restrictive. Again, remember, a single source is not defined in the statute, and it could very easily be interpreted as a single individual and a single entity. We believe we're actually taking a more expansive and inclusive approach by expanding the definition to include certain related entities. But we also think you have to be fair and practical under these circumstances. And these are client filers if they have actual knowledge, we think it's fair and reasonable that they aggregate. We don't believe, and we have not proposed that they have to do that kind of due diligence in seeking out that information.
So before I move away from A, so basically it means that if you have two brothers living in a house side by side, they wouldn't be covered as a single source, even if one brother called the other and said, let's contribute.
Right, but of course that means if each of them gave less than 5,000.
Well,
This only comes into play
For
if
aggregation
each contribution is less than 5,000.
Now, if we could move to B, which is for the organizational.
That's right.
Now, in the organizational draft regs, we don't have a similar limitation that they all be in the same office building or even the same office suite. Here, they could be anywhere in the country, and they're still being aggregated as a single source,
Well, we say that in
which I applaud. I mean, I
which is
applaud to be.
in the context of an entity, we say certain entities should be deemed so connected, so related that they should be deemed a single source. We don't think that's driven by location or address. For an entity, we believe it's driven by governance.
Can I, while we're on that point, can I just ask a question? One of the proposals, I think it was from Citizen United, wanted to broaden B to suggest that it also include entities that have shared decision-making authority, share a majority of board of directors, similar to the standard that's used for lawyers and conflicts of interest. Just want to know why it is that is not a provision that's included here.
We thought that became unworkable.
Too real?
If I-
Yeah, I mean, that's really the answer, by brand, so, I mean, that's,
Right.
but
Could we go to C on that, which is a sole proprietorship?
Yeah.
If it's a sole proprietorship, why would be that a different entity legally than the sole proprietor? It's an unincorporated body, so it's not an artificial entity.
I think sole proprietorships can be a separate legal entity, and in some circumstances are treated as separate entities from their proprietors.
And
But we say that it should be deemed
you're
as a
talking
single
about,
source.
you're talking about like a DBA?
Yeah.
Doing business as?
Mhm.
Okay. Now, if it's a sole proprietor running a small shop, and then we again have actual knowledge or reason to know of the relationship, why do we have or reason to know the relationship for a sole proprietor, and it's missing an A, which is two or more people for whom client filer is actual knowledge and lives in the same household? Why not reason to know there as well?
I don't understand the question.
Why is the definition for a sole proprietor broader,
Why do we put
more
reason-
inclusive than for two or more related people?
I think what we were trying to do, and we have been greatly informed by the public comment and conversations that we've had, and what we need to do here is maximize disclosure and implement the intention of the statute, at the same time balancing the interests and the burden on the regulated community, and we were trying to be sensitive to that. So in coming up with these rules, we wanted to be broad and inclusive, but at the same time, we wanted to be mindful of the consequences of that. So we believe it's reasonable, reason to know, and having some due diligence with businesses and entities that can be easily discovered or getting access to information online, we think that's reasonable. When you start getting into individuals and personal information, we thought that kind of shifted to maybe too much of it.
All right, let's go to 938.3, the contribution reporting requirements. At the June 7th public hearing, we had different starting points. One being July 15th of 2012 at the latest, and the earliest being August 15, 2011, when the law came into existence and everybody was on notice. We have the draft regs, however, take this to a date next year, to January 15th, which will then only look back from that date, January 15th of 2013, which basically cloaks everything else that happened before.
There is,
So instead of maximizing disclosure, we're actually minimizing it to non-disclosure.
there's no fair read of the statute that makes this disclosure requirement go back to August. So let's put that aside. My recollection of the hearing was the testimony provided, most of the groups testified that the disclosure requirement should start after the date that it's effective. It was effective June. Most of the groups were arguing and testifying that disclosure should go thereafter, which would mean July. There was some testimony and consideration to perhaps it could arguably go back to January of 2012, which was the earliest date. And there was some reference to that January of 2012, that January to June period perhaps being a possible date. But I think most of the groups, and I think a fair and reasonable interpretation of a statute that goes into effect in June, I think everyone was saying it's only fair to look prospectively. And I think also we have to give credit to the legislature for understanding how the lobbying filings work. And I think given that, it must have been that a June effective date took into consideration that June is the end of one reporting period, and then a new reporting period would begin in July. So I think the most fair and reasonable interpretation is that that it went into effect June of this year to apply prospectively to the very next reporting period, which is July through December, which you're right, would be filed in January. But it's January covering the reporting period July through December of this year.
I must respectfully disagree. The legislature and the governor signed a law and selected a date, June 1 of 2012, not July 1 of 2012. And the difference is critical because June 1 of 2012 is within the first reporting period from January 1 of this year through June 30th of this year.
Well, I think that is...
Let me just finish my point. So, because part of this is, to inform the fellow commissioners because we got to vote on this. So this 6-month period is then reported on July 15th of this year. So when the law purposefully chose a date of where it became effective, I mean, they didn't think we'd be doing our regs now, but June 1 was the date that the law selected, which is within the first reporting period. Hence, that triggers that 12-month look back, which is also statutory, which would then go automatically, if this is included, June 1, 2012 means it's got to be part of the July 15, 2012 report, which means the 12-month look back must occur. That's what the law says. That's a plain reading of the law.
Can I ask a question of the staff, and Ellen, maybe Rob knows as well. Are there issues with respect to enforceability and notice if the regs haven't been promulgated, notwithstanding the effective date? Meaning that if there are no regs and someone is subject to the law, but the regs are forthcoming, there are two questions I have. One is for the people who are obligated to report under the law without guidance of regs. What do they do as a practical matter and as a legal matter? And then from our perspective, from our side, were we to enforce the earliest period possible in the absence of regs, does that leave us vulnerable to legal challenge in the absence of promulgated regulation?
I think the quick answer is yes to that second question. And I think on the first question, there's even a more basic issue, which is just fundamental fairness first of giving people, obviously there are some open issues that we think the regulations are critical to give guidance to, and there's an issue of fairness.
Well, due
process. Exactly. But let me also make a practical point, Dan, on that, which is we can't even formulate the form on which they will make the disclosure until we have the regulations in place. Because how the information is collected and what exactly the form looks like is guided by these regulations. So as a practical matter, you have to have these regulations in place, not only for due process, but also for the practical compliance.
Right, so-
Isn't another practical aspect is today's July 31st? I mean, so the filing has already occurred.
Right.
July 15th, I believe.
That is
So,
right.
I mean, so we really can only be prospective in that sense.
Well, the use of the word prospective has legal meaning and implicates constitutional bar of ex post facto activity.
That's
But
correct.
that's not what we're worrying about, because the law came into effect on August 15, 2011. Everyone was on notice. It's June 1 of this year is when the trigger by law went into effect. We cannot be overruling the statute. We can't be overruling the governor. Signed the law saying June 1, 2012 is when this law is effective. And and these are sophisticated people who lobby government. This is not mom and pop operations. They know what they're doing. They got wonderful lawyers. They got wonderful lobbyists. They know what they're doing. And I don't think Jacob has the authority to overrule the governor and the legislature.
I would generally agree with you, but, you know, I start with Ellen's point that forget August. August means nothing in this discussion here. Okay, so now
I
we're
don't know where
dealing...
August fits in at all. I mean,
Well, you raised it.
No. What I meant is the law went into effect on that
Yeah.
day. So ignorance of the law is no defense is all I meant. So prospectively of August 15, 2011, the law is valid. We're not saying go beyond or go prior to August 15, 2011. We're saying even the 12-month look back, which is in the statute, I think a judge, if he had to decide, might say, well, you know, you can only look back up to August 15, 2011, because that's when the law went into effect.
I'm not sure what Vinnie's feelings are, but overruled.
Your Honor,
I mean, you can't, Robbie, respectfully, you can't pass a law that says everything we're going to tell you in the future is a crime, and then try to apply it retrospectively, and then argue that you were on notice that it would be a crime. And that's almost what you're advocating.
Especially.
I mean, how could you possibly be on notice of what activity would violate a statute when all we did was generically say, something you may do may be a crime? You have to guess for the meantime until the regs come down. So the fact that we're going back at all is troubling to some, let alone going back even further. And I happen to be one of those some.
Especially after we've had public hearings where we've made public announcements that regulations are forthcoming to give guidance and legal effect to what the law requires. So, I mean, the public has been waiting for these regulations. That goes to your point about, Ellen's point about fundamental fairness, independent of any legal obligation for due process.
I do want to also just make the purpose for clarity. The 12-month period, that look back that we talked about, it is confusing, but don't conflate the 12-month period, which is the time period in which to determine whether you meet the threshold. Don't conflate that with any of the other time periods. That is in the statute, that's driven by statute. There's a time period that is, what is the time period during which you look at to determine if you've met the threshold. That is very different from what is the time period in which you must disclose.
You know, to Dan's point, on June 7th, I think our chair made an announcement that, or maybe at the May 30th meeting, that people who filed the July 15th reports may need to amend them based upon the regs that come down. You know, so that I think that the public is aware that these regs are coming down, and there's still a SAPA process to go through, and so on and so forth. So depending upon when Jacob finally passes these regs, it may well be past January 15th of 2013 by the time we're done. So that means up to the time we pass the regs, everything prior to that is cloaked.
Well, but give Jacob some authority under the statute. The statute requires Jacob to provide the rules and regulations for the implementation of that law. That's what we're doing. And there has to be the exercise of some kind of understanding, appreciation of the needs of the regulated community, as well as the needs for the clarity to get the regulations so that we can implement the intent of adequate public and extreme disclosure if necessary.
Who
think
could
that-
disagree with you? I mean, I understand that. My only problem is the law says it's effective June 1, 2012. So are we overruling the law?
I don't think so. I think that the law says that we have the right to implement the rules and regulations to implement this statute. And if we do it as well as I believe it has been done here, I think we're doing our job.
And just to add to the judge's point, I'm not sure why you characterize it as overruling. I think the commission is being asked to interpret what does it mean to be effective June 1. And I think the fair and reasonable interpretation of being effective June 1 is that disclosure starts July, because that is, it's all about the client semi-annual. This is a disclosure that's aimed at clients. The reasonable interpretation of being effective June is putting them on notice that starting the next reporting period, that's when the disclosure would apply. Is that the only interpretation? No. There is an interpretation, and we saw it in some of the public comments, that perhaps it means you go back to January of 2012, and you look at the reporting period January through June as the first reporting period. That's a possible interpretation, but we found that that was not the most reasonable interpretation. And we think the most reasonable and fair interpretation of being effective June 1 is effective the very next reporting period.
And the January 1 of this year to June 30th of this year is the period that's covered by the July 15, 2012 report.
Filed in, right, the July,
Correct.
January through June 30
Right.
is covered in the July
July 15.
filing.
Okay.
Right.
And so that's why we go to the beginning of the year until the end of June of this year for a July 15th report. Is that right?
January through June is covered in the July filing.
Perfect. And as you, I think you said as well earlier that the legislature and the governor knew about the reporting requirements and when those reports are due. So for them to purposefully select a June 1 effective date, which is within the reporting period for a report to be filed on July 15th, how do we have the power to overrule them?
I mean, I think we're just going over the same point. What I've just said is, I don't see how this has anything to do with overruling. I think it is the commission's, it's up to the commission to determine what does that mean by saying it's effective. And as I've said, there were some, and there was certainly discussion of, does it mean you go back to January through June? But I think the more fair and reasonable interpretation is July, that it goes into effect July.
The effectiveness of the legislation as of a given moment in time has a lot more to do with other than these deadlines that we're talking about. There was a previous commission that was put out of business and a new commission that was put into business. And I think that there is clarity enough in the statutory language, and I think that the legislature and the governor obviously agreed on it, and it made sense. The implementing power and authority given to this commission really trumps everything, and it depends on our good sense and deliberate dealing with the issues involved in this total package called ethics and disclosure.
I think we have the...
So the next topic, which is a standard for reviewing an application for exemption. Under 938.4, you've got A and then B. So I'll go to the A first, which I consider a retail exemption, and B as a wholesale exemption.
938.4?
938.4, standard for reviewing an application for exemption. And I was just saying 938.4A, I consider to be a retail application for exemption, and B as a wholesale exemption application. So let me just go to the first standard issue. You know, I'm reminded by America's Mayor Rudy Giuliani in October of 1999, when he was still mayor. the KKK wanted to walk outside Foley Square, and he refused to give them a permit, and it went up to the Second Circuit, and he was affirmed that if they wanted to walk and engage in First Amendment exercise rights in the public square, they weren't entitled to a mask. People needed to know who's doing the talking. And I think that's critical goal of source funding regulations. And I'm not sure we're getting there. Because now, not only in the definitional issues that we've covered, now we go to exemptions. And the way this is written, the commission is outsourcing our power to an independent JHO who's going to make a determination. Should these generally not be where the JHO is a hear and report and the commission decides rather than a hear and determine?
Well, the premise is wrong. The commission makes...
Please explain, because that's how I read it.
First of all, understand the exemptions are required by the statute. We're just giving standards and a mechanism. The determination is made by the commission. That's it. The statute provides that there is an appeal process, that there must be an appeal heard by an independent judicial hearing officer. So all that is provided is for an appeal by that independent judicial hearing officer of the commission's determination.
But just to frame this a little bit, just because I think Ravi sort of, I think, I don't know if I mischaracterized you said, I apologize, but essentially, I think...
I'm trying to minimize.
Right, you were trying to suggest that somehow this is an exception that will swallow the rule, that somehow this exemption process will enable large numbers of the fair import. What I thought you were saying was that this will enable large numbers of filers to become exempt from the source reporting requirements. And I'm reading this, and I see the criteria for the exemptions as individuals who have been subject of past or present harm, threats, harassment, reprisals. I mean, these seem to be, I mean, I'd like the staff to comment. I mean, these seem to be extremely narrowly drawn exemptions in my reading.
These are rigorous. I mean, the exemption and these, we were very informed not only by our own thought, but by the comments on this, which is statute provides that there needs to be a mechanism for exemptions, but the exemptions need to be it needs to be a very rigorous standard. It needs to be an exacting standard, and that's what we provide for. That clear and convincing standard is a very real and difficult standard to meet, and it is a determination that is made by the commission.
Thank you, Dan. I'm still confused. Under 938.4A, there are 5 categories listed. Originally, the particular reason for the exemptions was to protect, for example, those who support abortion clinic issues and NAACP rights type
That's
activity.
B. That's B.
Okay. Well, no, I understand. But with respect to when you have specific, let's go to one, for example, specific evidence of past or present harm.
Let me just interrupt you, because these are some of the factors that the commission might consider in making its determination. These are not all of the factors. It is a totality of the circumstances, and any one circumstance might be compelling for other reasons. We've indicated some factors that the commission will consider in these applications, but these are not exclusive or dispositive. It is in the commission's discretion, and we're making it clear that this is a very difficult standard to meet. And it's only when there's clear and convincing evidence that a source will suffer some type of harm or threat or reprisal that we will make that determination that they should be exempt from disclosing that source.
If you go to 3, for example, under A3, and quote, a pattern of threats or manifestation of public hostility against a single source or client filer or individuals or property affiliated with the single sources or client filer, end quote. I mean, does that mean that after BP, for example, had the oil spill in the Gulf of Mexico and they engaged in public relations or 501c4 channel lobbying, that they would now be exempt because people may actually be upset with the environmental disaster that they caused?
I think what's very clear here is, as I said, no one factor is exclusive or dispositive. But what is clear is there's got to be a very real showing of evidence of real harm or threat. And I think just a general concern that there is public hostility based on public reporting or the fact that people are speaking negatively about a company will certainly not be enough.
These exemptions all come back to the commission on recommendation of the staff, and it is the commission that decides to grant, or is it the staff that decides to grant?
The way it's currently written, it's the staff.
The way it's currently written, it says the commission.
The commission.
Yes, but
That's not.
there's a delegation of authority.
I
That's
think,
just that we haven't delegated anything yet.
to be clear on that, I think it is a matter that could be delegated to staff.
It could be delegated. The reason I raise that now is because of some of the points being raised by Commissioner Best.
I don't
If
think.
everything comes right back to this table, and you come to this table and you say, applicant has met the standards because, we can then talk about some of the details that Commissioner
That
Bach
is
is
correct.
raising. But if we're going to delegate all of this to staff so we don't know whether exemptions are being granted and who is receiving them, except when we look up on the website when it's too late, I think we got to come to a conclusion about that, because right now it says the commission. I'm assuming it's the commission. I see no delegation in here, nor has anybody asked for it.
And I don't think the regulation needs to address that point. I
Okay,
think that's the
but
point for the
you should
commission.
have an understanding.
Well, let me ask this question, Ellen. There's a broad delegation already in place.
That's correct.
How do you read that delegation vis-à-vis what Marvin is raising?
Exactly.
I mean,
I read that delegation as permitting staff to make these types of determinations, but every delegation is, of course, always subject to the commission.
Well, I don't think an exemption of this nature, where we're literally denying the public the right to know who's talking to them through a mask, ought to be left at that level, and then go to a JHO who can make a hearing determination. I think even the JHO appeal process has got to come back to the commissioners, not to staff. It can't be self-authenticated.
I
It's
think
the
that's
commission's prerogative to make that determination.
Isn't the JHO, that's statutory?
That's statutory.
Yeah,
But-
that's the.
Yeah.
It's statutory. It's driven.
Determined?
Yes.
Yeah.
The appeal
Then even
determine,
more so, we need to be involved in the exemption process.
well, that's the commission's prerogative.
Yeah.
But that's not to be
That's
addressed.
That's an issue I raise, which we're going to, as a commission, have to determine whether we want it to fall within that broad delegation or not.
Correct.
I just want to give.
Exemptions are important.
Yeah, but if it says the commission may grant, in both cases,
Right.
the commission may grant. If you want to put some ice on that, we can say the commission by its vote.
Exactly.
And
By its
get on with it.
Yes.
So
Exactly.
that the
That's
broad
what we're talking about.
grant of delegation does not
Exactly.
affect this particular
Exactly,
activity.
exactly.
Okay.
Exactly what we're talking about.
Just to add to Commissioner Jacobs' point, some of the concerns I have is, for example, we've always attempted to block foreign money from entering into American politics. We don't allow foreign money to come in as campaign contributions. In fact, it's federal crimes to that effect. Under the 501c4 process, tax exempt no less, coordinated with a candidate or a campaign, no less. If we mask who's involved, what's to prevent foreign money? What's to prevent alien money?
Isn't that criminal?
But whether it's criminal or not, how can we be derelict in our duty to prevent that from occurring?
The exemptions are required by the statute. That's not us. We're
No.
just implementing the
I
exemption.
understand. They only say give exemptions, and they give cites for the NAACP and the civil rights and the
It's
abortion
up to the
clinics.
commission to determine whether any
But we're
individual
flushing them
source-
out. we're flushing them out. But I'm just saying contextually, those are the risks that we have to ward against to protect New York.
I just don't see anything in this iteration that suggests that we're going to facilitate the contribution
Right.
of offshore money into campaigns.
Very easy.
I mean, I completely and respectfully,
Disagree.
wholeheartedly disagree with you.
Well-
And I can guarantee you that I'm not the only person at this table who agrees with me on that.
And also keep in mind, obviously, the context. This is a new disclosure requirement. This is an area where disclosure has never been required before. We are maximizing disclosure in a way that is unprecedented.
Well, I think certainly with the reportable business relationships, I think that we've met that goal. I'm not sure about source funding, but going to Commissioner Horowitz's point, a corporation, a foreign corporation, and sitting in London, has a subsidiary in New York, and the subsidiary in New York gives to a 501c4 newly established. If the 501c4 is masked, we'll never find out it was foreign money, and that's how it is. So whether people get it or not, it's a matter of their exposure to life.
Look, these guys, the staff is more familiar with these draft regs than I am, but you're hypothetical, and I don't really want to get into the weeds with you. But under your hypothetical, we would have disclosure because it's an affiliated entity, and if the organization and the corporation is here, then they're required to disclose. But in any event, I don't want to take the other commissioners' time and belabor it.
Have you any ability to forecast the number of exemptions that might come in once all this goes effective? In other words, how burdensome will the exemption process?
We could write the statute that way.
If you got to bring it.
Name the entity.
You got to bring it to the commission table.
Well, I mean, we are concerned about that. It is a rigorous process, so it's not as simple as just checking a box. I mean, the process does require that there be submissions to show evidence.
Paperwork.
Right, evidence to meet the standard. And in fact, we provide in the regulations that the record that's presented in the application for exemption is the record that will be reviewed. So even when it goes up on appeal, they've got to put all of the information up front. So it's a real process. That said, though, I think you're right. I'm sure there will be multiple applications.
There will be multiple, but I, for one, as we kick off this unprecedented process, would like to see these requests for exemptions, at least initially, until we get some experience with the flow and with the number and with the kinds of exemptions that are requested, that they come to this table rather than they be done by staff without oversight.
Well, I think that point had already been made by the judge, which is if you added the language, the commission by its vote, then.
I'm just saying we ought to do that.
I concur with that. My question is, how do we do that? Do we now make a motion that says the commission by its vote as part and parcel?
Well, I did,
I was going to propose a motion.
Wait.
My only concern there is if the commission does say by its vote, then it can't be delegated to staff.
Correct.
And I think you may want to consider having some language that it's always in the commission's prerogative to say you don't want to delegate information, but you might in the future want to delegate, given the volume.
Well, we can always do that.
Well, you can't if it says by its vote.
It's only a reg, and we vote the regs in, and we can amend them, I suppose.
All right.
I think it would make more sense to have a little more flexibility in the language and have an understanding by the commission that at the outset, it's the authority you want to retain with the possibility of delegation in the future if you want.
It just strikes me that these were never intended, I don't think, to be a final and definitive piece, right? We're embarked on an evolutionary process to refine and modify as we learn new things. And I mean, to conjure up possible exceptions and what-ifs now, I think kind of deflects us from where we need to go. We need to focus on whether this represents a good first start and whether there's enough goodwill to deal with questions, what the commission will see, and move forward.
Can I just say for the record, I agree wholeheartedly with Commissioner Horowitz. Ravi, it is absurd to me that anyone would look at this narrow exemption and think it has anything to do with the Klan offshore accounts, or et cetera, et cetera. It just, no fair reading of this regulation has anything to do. And I would respectfully request that we move on.
Well, I appreciate that comment, but when you use the word absurd, I have a right to reply, and I will tell you what is absurd or not depends upon our life experience and how much we've been exposed to the world. So I'd like to make a motion, please.
Do I take that as an insult? Is that how
No,
I'm supposed
that
to
I
take
was
that?
insulted by
Okay.
your observation and characterization.
Ravi, are you finished with, because
I was going to make a motion on this.
oh,
You have a
okay, no,
question?
go ahead. You make your motion, then
Do you have any further comments on the regulation? Maybe someone else?
Yeah,
Someone else?
yeah.
That's what your point was, George?
Yeah, I figured Ravi.
By all means, go ahead, George.
First, I want to commend staff, Ellen and staff. I think, it's a good job. It really, given the circumstances. I'm hoping in terms of the single source, which is a really interesting and a new construct, that we're going to have robust comments on that particular part. The only concern that I have, and I know you pointed it out in terms of fungible money, is that last provision of the 3% or $50,000, that $5,000 or more was used for lobbying. And the legislature put that in there for some reason. I don't know if it's...
You're talking about when are funds deemed
Yes.
used for lobbying?
Yes, the language of the statute. And our proposed regs, I think, may go beyond that, which I believe is a limitation. And so hopefully, again, through the notice of comment rulemaking, we're going to get some feedback, because I believe in some of the testimony we had, one entity, we'll just call it that, said it doesn't work, so don't apply it. You can't do that. Others have come closer, I think, to where these regulations are. I'm just not sure that really reflects where the legislature...
I think listen, you're right. What does it mean for funds to be used for lobbying activity? It's open to a lot of different interpretation. We saw that in the public comment. We think we've ended up in a place that is consistent with the law, is consistent with maximizing disclosure, that is the intention of the law, and we also think it's a practical and common sense approach.
But as you recall, this is the public, especially the public, may not appreciate how much work you've put in, but how much we've spent, the hours we have spent among commissioners and telephone conferences to arrive at the drafts and redrafts, but the final draft that got here just this morning. But one of the points that was made in one of those conferences where commissioners were present was exactly that. You've got a 50,000, 3%. 97% of this entity's expenditures, compensation, whatever, activities, may deal in other areas altogether, yet under our interpretation of single source, we take every contribution, 5,000 and more, whether the contributor disclaimed any intention for this contribution to be dedicated to lobbying, as a reportable item. And you in your introduction, Ellen, talked about 3% may sound like a little, but it's really a lot. I think it is a little. 97 versus 3 is a vast difference there. So I think we have set up a standard that is going to be questioned, as Commissioner Weissman indicates in this reporting. And I continue to question it. I raised it twice during those conferences, so did Commissioner Weissman. And I re-raised it because I don't want to leave anybody in the room with the assumption that this is a done deal on that standard. And I think it would be fair to say it isn't, because I'll be coming back to it. I think you will be coming back to it. Others will. So I think it ought to go out for comment, of course, in the 45-day comment period. We're going to be hearing.
Can I make a motion?
I just want to, following your compliment, Marvin, the staff and the chair, set up an incredible process of conference calls, and we all got a presentation by Ellen and then we were all allowed to ask questions, and a lot of our questions were put to rest or at ease before today's meeting. So I semi want the public to understand that the silence of all the other commissioners is because we've already vetted a lot of our concerns, and we've already made some compromises, and we've already redrafted several times. And that's through the good graces of the chair and Ellen, and taking the time before coming here today, so we wouldn't be here for 2 days, to try to work out a lot of the problems and invite comment. And you know, there are some things we want to revisit, but I think it's commendable that no one is trying to, I don't think anyone, I don't know what the motion's going to be, but I don't think anyone's going to try to obstruct this product from going out, even though some of us may personally feel there's an issue here or there.
Exactly.
Madam Chair?
Yes, sir?
Following up, and I join in every commissioner who has applauded the staff, but particularly I want to include your leadership, Madam Chair, because as one of the commissioners said, we're sort of like Star Trek, you know, we're going where no one's gone before. So we're creating a lot of regs in a difficult area, and the purpose is extremely important, which is why JCOB was created. So with that, I just want to say that I want to move the adoption of the source of funding regs as currently written, and by that I mean the last version. There were 2 versions that were circulated both yesterday, one at 12:21 p.m. by email and one at 8:27 p.m. I have, of course, been dealing with the 8:27 p.m., which is the later version. So those draft regs that was put out by the staff after doing a yeoman job of putting flesh to this very difficult and important area, that those regs be adopted by the Commission with the following 3 amendments. A, in the definitional portions, and I'm looking at page 3 of the 8:27 email, 8:27 p.m. email of last night. Responsible party, single source, A. Right now it says 2 or more persons whom the client filer has actual knowledge live in the same household. My amendment as to that is that it become 2 or more persons with whom the client filer has reason to know are relatives. Okay, that's one amendment. Second amendment is the 938.3A, which is the reporting requirement. And I'm driven by the genius within the enabling statute of June 1/12 start date, that the starting date, so 938.3A uses the date January 15, 2013. That should be replaced by July 15, 2012. And the third amendment, which will cure many ills and many concerns, is in the standard for review, an application for exemption, page 6, 938.4A. As Commissioner Jacobs said, after the first 2 words, the Commission, by vote, may grant an exemption. So the amendment is to insert by vote, which means the authority to grant an exemption belongs to the commissioners and not staff. And of course, staff is always free to make recommendations for any exemption, as for anything that the commission does. So I don't think we need to worry about that too much. So with those 3 amendments, I ask that the single source draft regs as drafted by Ellen and her wonderful team be approved.
Can you just make a point of clarification?
Sure.
For consistency's sake, the by vote should be inserted in 938.4B as well.
2 places.
Right. As well. Yes, please. Thank you very much. That's why we need you.
No, second, then.
Yeah.
Does anyone care to second that? Is there another motion?
I make a motion that we move to approve the regs as proposed.
Is that with the
All in
addition?
favor?
No.
Aye.
Any opposed? Motion is
We're
carried.
approving them to go out for notice.
Yes, for the
Right.
process.
Yes.
Okay.
Fine.
Did we get the votes? Because I just want to,
Yes.
you're good?
Yes, there was only one nay.
Okay.
Okay. Next.
Guidelines.
Got it.
You need a motion for the guidelines?
Guidelines. And the proposal there, as I said,
I move to adopt the guidelines. No problem with, oh, I second yours.
and just, the proposal there is we will post them as having been approved as proposed guidelines. We will solicit additional public comment, and we will come back to the commission if there's a need for any significant revision.
All in favor?
Aye.
Aye.
Opposed?
Perhaps significant revision part.
Yeah, I would seek to modify that.
Revision,
To come back.
regardless of whether it's significant.
If there's any revision, we will come back.
Comment period that we return
Who got
We
that
will
motion?
come back
to the commission, yes.
Okay.
to finalize them.
Okay, moving right along. Is there any new or other business? Okay. Is there a motion to enter into executive session pursuant to Executive Law, Section 9419?
So moved.
Second? All in favor?
Aye.
Any opposed? Okay, we are moving into executive session. Okay, we're back in the public portion of today's meeting. There are no public announcements to be made based on any action that may have been taken in the executive session of our meeting. Is there, the only business left is a motion to adjourn this meeting. Is there a motion on the table?
So moved.
Second?
Second.
All in favor?
Aye.
Any opposed? Motion to adjourn is carried. See you all on August 28th. Thank you.